Everyone, I'm Dr. Kalpana. In this lecture, we would be dealing with an overview of labor economy and laws governing industrial relations in India. This presentation offers a comprehensive overview of Indian labor law economy and intricate legal framework governing industrial relations. We would be locating the unique characteristics of India's labor market, examining diverse categories of labor legislation, and explore the mechanisms for industrial dispute resolution. Our discussion will also highlight significant case laws and real life examples to provide practical insights into complexities of crucial sector. Key characteristics of Indian labor market predominantly we unfortunately are 90% of India's workforce operates within informal sector. Informal sector means upon whom labor legislation do not apply, characterized by lack of formal contracts, social security benefits, and regulatory oversight. Low union density. While overall union density is low, trade unions maintain significant influence and presence within organized sector, play vital role in collective bargaining and industrial relations. Regional disparity. India's diverse geography leads to significant regional variations in employment laws and their enforcement, requiring a nuanced understanding of state-specific regulation. Impact of globalization. Globalization has driven trends such as labor casualization, increased outsourcing, notable decline in traditional job security, reshaping employment dynamics. So these characteristics highlight the complex and evolving nature of Indian labor market and demanding adaptable legal and human resource strategies. Understanding these foundational aspects is critical for navigating the challenges and opportunities within this dynamic environment. Industrial relations laws, that is one of the most important legislation, Industrial Dispute Act 1947. It came into being when India got freedom. This foundational legislation provides the framework for investigation and settlement of industrial disputes. It outlines the procedures for strike, lockouts, layoffs, retrenchment, closures, aiming to maintain industrial peace and harmony. This act is crucial for regulating relationship between employer and workman, ensuring fair practices in the event of dispute. Trade Union Act. This act grants legal status and protection to trade unions in India, enabling them to register, function, represent the interest of their members. It defines rights and liabilities of registered trade unions and their members, providing a legal basis for their activities in collective bargaining, and addresses workers' grievances. And this legislation is vital for fostering organized labor movements. Wages and compensation legislation. Minimum Wages Act 1948 mandates the payment of minimum wages to the workers in scheduled employment, ensuring a basic standard of living and preventing exploitation. Wages are determined by central and state government based on various factors. Payment of Wages Act 1936 regulates the timely and authorized payment of wages to the employee, preventing arbitrary deductions and delays. It specifies the wage period, time for payment, and permissible deductions. Equal Remuneration Act 1976 prohibits discrimination on the basis of gender in matters of remuneration for work of equal value. It aims to ensure equal pay for equal work regardless of sex, promoting gender equality in workplace. These acts collectively safeguard the financial well-being of workers by ensuring fair, timely, and non-discriminatory compensation practices across all the sectors of employment in India. Working Condition and Social Security. Factories Act 1948 governs the health, safety, welfare of workers in factories. It sets the standards of working hours, ventilation, sanitation, machinery safety, ensuring safe and conducive work environment. Labor Contract Regulation and Abolition Act 1970 regulates employment of contract labor in certain establishments and provides for its abolition in specific circumstances. It ensures welfare and safety of provision for contract workers, preventing their exploitation by principal employers, Employees Provident Fund and Miscellaneous Provident Act 1952 mandates a provident fund scheme for employees to provide retirement and social security. It is a significant long-term saving instrument for workers. Employees State Insurance 1948 ESI, you must have heard, provides for certain benefits to employees in case of sickness, maternity, and employment injury. It is comprehensive social security scheme covering medical care and cash benefits. These legislations are crucial for establishing minimum standards for working conditions and providing a safety net for workers through comprehensive security measures. Transformative new labor codes post 2019 reforms, code on wages consolidates for four existing laws relating to wages, aiming to ensure universal minimum wages and timely payment of all workers, simplifying compliance for employers. Industrial Relation Code 2020 amalgamates three labor laws concerning industrial disputes, trade unions, standing orders. It seeks to streamline dispute resolution and enhance ease of doing business while protecting workers' rights. Occupational Safety Health Working Condition Code 2020 merges 13 existing laws related to safety, health, working conditions. It aims to provide unified framework for ensuring safety, health, and welfare standards across various establishments. Social Security Code 2020 consolidates nine social security legislation, expanding the scope of social security benefit to include gig workers, unorganized sectors, employees, and a significant step towards universal coverage. These new codes represent a significant legislative reform aimed at simplifying India's complex labor laws, promoting ease of doing business, and extending social security coverage to broader segment of workforce. Industrial dispute resolution mechanism, internal mechanism, work committees, grievance redressal. These mechanisms provide direct dialogue and resolution within organization, often first step in addressing employees' grievances and fostering cooperative environment. External mechanism, conciliation, adjudication, labor court, and tribunals. While internal effort fail, external bodies intervene. Conciliation involve a third party for facilitating agreement, while adjudication involves formal legal proceedings and binding decisions. The effective functioning of these mechanisms is vital for maintaining industrial harmony and ensuring that disputes are resolved efficiently and equitably, preventing escalation into larger conflicts. There are some case laws, real life implications, workmen in Daimakuchi tea estate. There are important case laws and real life implications. Workmen of Daimakuchi Tea Estate versus Management. In 1958, this landmark Supreme Court judgment significantly broadened the definition of workmen under Industrial Dispute Act, extending protection to wider categories of employees and impacting numerous industrial relations. Bangalore water supply, another important, significant judgment, is very popular case. This case provided a very broad and inclusive definition of industry under Section 2J of Industrial Dispute Act, bringing more organizations and establishment within the purview of labor laws, regardless of their profit motive. Maruti Suzuki violence. This tragic incident at Maruti Suzuki Manesar plant exemplified the critical failures in labor relations. It underscored the severe consequences of inadequate grievance redressal mechanism, poor HR management, and breakdown in communication, leading to violence and significant operational disruption. This case serves as a stark reminder of importance of proactive and effective industrial relation strategies. With this, I would end here.